Okay, this next question is a little bit longer and kind of multi-pronged, but I thought it was a good question to have on here. In this question, the scenario that the person who emailed us presented was they were working a job, and because of an injury not related to the job, they had certain physical limitations that disqualified them from the position they held. The first part of the scenario dealt with the employer or the organization for which this person worked offering them other positions which were technically considered downgraded positions and offered at a lower salary or lower rate of pay. So the first part of the question from the author, if you will, was whether or not this was appropriate. Now, while we do handle some labor and employment stuff here at our office, most of it dealing with wage cases, this was one that was a little bit outside of what we normally handle. So I reached out to a good friend of mine, Neil Hyman, with the law offices of Neil Hyman in Bethesda, Maryland, to help me out with this question. Now, in speaking with Neil, he indicates that it is appropriate in trying to make reasonable accommodations under the Americans with Disabilities Act and the Act amendments to offer a downgraded position with less pay, but usually that should kind of be reserved as a last resort. The next part of the question from the author, or the next part of that scenario, dealt with a situation in which they had applied for a job that did not include any physical requirements on there, and ultimately, after interviewing, were not given that job or that position. And the question from this person was whether or not that was the appropriate way for it to be handled. Ultimately, a candidate should be interviewed without any consideration of a disability. If the candidate would otherwise be qualified for the position, then the employer has to make a determination as to whether or not an accommodation is required. And generally the best way for them to do that is to kind of engage in an interactive dialogue with the employee or prospective employee to determine what, if any, accommodations would be necessary and whether or not they can meet those physical requirements. The bottom line here is the candidate, or in this case the employee who was looking for another position within the same organization, can't be automatically disqualified because of the disability if they're otherwise qualified for the position. The thing to keep in mind here in speaking with Neil is that in any situation where you think you are considering bringing a claim of harassment or discrimination against your employer, you generally have 180 days from what we would call the adverse employment action to file charges with the EEOC, the Equal Employment Opportunities Commission. If your state has a referral agency, for example, it could be a state, county, municipal, or similar jurisdiction, generally you have 300 days to file your claim with the EEOC, plus the referral agency will have its own filing deadlines that don't necessarily track with the EEOC deadlines. So again, this may be an area you may be comfortable to an extent trying to deal with it yourself, but once you start getting into deadlines that can impact your ability to maintain or even bring a cause of action, you might be better off speaking with an attorney that specializes in labor and employment.